Welcome to this explainer. Look, after your home, your retirement account is probably the absolute largest asset you own. But here's the thing, passing it on to your loved ones isn't as simple as just jotting a name down on a random piece of paper. Today, we're diving right in to unpack exactly how to master your beneficiary designations, secure your wealth, and completely protect your family's future.
To kick things off, we have to look at a genuinely shocking Seventh Circuit court case. It perfectly proves that your intentions mean absolutely nothing if your paperwork isn't perfect. You know, we all like to think that our clearly stated wishes will be honored when we're gone. But in the highly regulated world of retirement accounts, the law looks at forms, not your feelings.
So, here's exactly what happened. A guy participating in the Packaging Corporation of America's 401k plan went through a divorce. Naturally, he wanted to remove his ex-wife as his beneficiary and leave the account to his sisters instead. He even had his secretary fax a formal request to his employer's benefits center asking to make the change and requesting any necessary paperwork. But he never actually completed the official change form. So, when he passed away, a massive, bitter legal battle exploded between his estate and his ex-wife.
Let's move into Section 1, Why Beneficiaries Truly Matter.
In that court case we just talked about, the judges applied something called the substantial compliance test. The court ruled that, yeah, although the man clearly intended to change his beneficiary, his fax didn't meet the legal standard under federal law. Why? Because it just wasn't similar enough to the plan's strictly required official mechanism. The result? His ex-wife legally walked away with the entire 401k, and his intended heirs, his own sisters, got absolutely nothing. Love may fade, you guys, but beneficiary designations do not. It's incredibly vital to understand that a beneficiary designation on a retirement account is essentially a trump card. It completely overrides any conflicting instructions you might have written in your will. See, retirement accounts like IRAs and 401ks are known as beneficiary designation assets. They transfer upon your death based only on the official form sitting on file with your financial custodian. If your will says your new spouse gets everything, but your old 401k form still lists your ex-spouse, the ex gets the money. Period. No exceptions.
All right, Section 2, the step-by-step process. So here's your concrete action plan. Step 1, gather complete biographical data for everyone you want to name. We're talking full legal names, dates of birth, and social security numbers. This prevents massive administrative headaches when your family eventually goes to claim the account. Step 2, if you're married and naming someone other than your spouse on certain accounts, you have to secure a formal, notarized spousal consent waiver. Step 3 is submitting the official form provided by your actual custodian. And finally, and I cannot stress this enough, Step 4, you must obtain a formal, written acknowledgement of acceptance from your plan custodian and file it away with your estate documents. Do not ever just assume a form is processed just because you mailed it or clicked submit on a website. Now, the rules you have to follow are actually dictated by your specific account type. For example, employer-sponsored plans, which are governed by a federal law called ERISA, automatically default to your surviving spouse. You literally cannot leave a 401k to your kids if you're married unless your spouse actively signs a waiver giving their legal permission. IRAs, on the other hand, offer way more flexibility for you to name whoever you want without spousal consent, unless, of course, you live in a community property state like Texas where your spouse still holds a legal interest in the account. Let that number sink in for a second. 0. None. Zilch. That is the exact number of times your beneficiary designations automatically carry over when you roll an account over to a new institution. If you leave a job and roll your 401k into an IRA at a new brokerage, your old beneficiary form immediately becomes void. You have to execute brand new forms every single time you move your money to a new custodian. Which brings us to Section 3, Key Considerations and Pitfalls. Let's go over the absolute biggest blunders people make. First, leaving the form blank, which often defaults the account straight to your estate. Second, naming minors directly, like literally writing your 10-year-old's name on the dotted line. This is a massive mistake because financial institutions will absolutely not hand over hundreds of thousands of dollars to a child. It forces the court to step in and appoint a guardian, completely draining time and money. Always use a trust or a formal custodian under the Uniform Transfers to Minors Act. And finally, failing to name a contingent or backup beneficiary. If your primary heir passes away before you, your account is suddenly left without a designated home.
Let's really zero in on that first mistake, the estate. If your estate becomes the beneficiary, whether you actually named it or you just left the form blank and the default rules kicked in, it forces all those tax-advantaged assets into a public, incredibly costly probate process. And even worse, it completely strips the account of its incredible tax deferral benefits. It triggers something called the IRS 5-year liquidation rule, or a ghost life expectancy rule. Basically, instead of your heirs enjoying years of tax-advantaged growth, they could be slapped with a massive, immediate income tax bill.
Now, estate planning is full of confusing jargon, right? But checking the per stirpes box on your form is one of the simplest, most powerful ways to protect your legacy. Imagine you have 2 kids, and tragically, one of them passes away before you do. If you have per stirpes selected, that deceased child's share automatically bypasses them and flows directly down their family line to their children, meaning your grandchildren.
And the contrast here is absolutely vital. If you don't explicitly choose per stirpes, many custodians out there automatically default to a standard called per capita. Under per capita, if that same child predeceases you, their share does not go to your grandkids. Instead, it gets redistributed entirely to your remaining living children. Just think about that. A simple missed checkbox could accidentally disinherit an entire branch of your family. If your custodian's form doesn't actually offer a per stirpes checkbox, you need to contact them directly to have it custom added to your file.
And this all builds into a pretty harsh reality your heirs might face, thanks to a recent piece of legislation called the Secure Act. The good old days of stretching out inherited IRA taxes over a lifetime are mostly dead and gone. Unless your heir qualifies as an eligible designated beneficiary, like a spouse or a minor child, most non-spouse beneficiaries, like your adult kids, are now forced by the 10-year rule to drain the entire inherited account within a single decade. And trust me, that can heavily impact their own personal tax brackets.
Okay, Section 4, Navigating Major Life Events. You really have to treat your beneficiary designations as living, breathing documents. You should be auditing them immediately after any major life event to make sure they still match your actual wishes. Getting married? Review the forms. Having a baby? Review the forms. Did a designated beneficiary pass away? Review the forms.
Let's talk about divorce for a second, because this specific scenario traps thousands of people. Many states actually have laws in the books saying that getting divorced automatically revokes your ex-spouse's status as a beneficiary. But here is the massive catch. Federal ERISA law, which governs your 401k, totally preempts state law. The Supreme Court has literally ruled on this. In plain English, even if your fancy property settlement agreement says your ex gets nothing, if their name is still on your 401k form when you die, federal law ensures they get the money. Just like the guy in our earlier court case, you absolutely must manually submit a new form to remove them.
And listen, if you or your beneficiaries mishandle these accounts, the IRS is just waiting in the wings. Be super careful, because missing a required minimum distribution, or RMD, due to improper estate handling now triggers a steep 25% IRS excise tax penalty on the shortfall. If the account isn't correctly titled to the proper beneficiaries right on time, this penalty can quickly eat away at the wealth you worked your entire life to build.
And finally, Section 5, Conclusion and Vital Disclaimer.
Naming a beneficiary isn't just some annoying bureaucratic chore. When you actually do this right, by keeping forms updated, understanding the tricky tax rules, avoiding the terrible estate default, and getting written confirmation from your custodian, you are ensuring an incredibly smooth, protected transition of your wealth. You're giving your heirs the gift of tax-deferred growth and completely bypassing the nightmare that is probate court. So I'm going to challenge you to take action the exact moment this explainer ends. Grab a cup of coffee, log straight into your retirement accounts, and verify exactly who is listed on those forms. Check for those contingent beneficiaries. Make sure you have the per stirpes designation if you need it. And if you've recently rolled over an account, make sure your designations didn't just get left behind in the ether. After all, do you want your life savings going to the people you actually love, or to an ex-spouse you haven't spoken to in a decade?
Before we wrap up, please remember, this information is intended as general guidance and for educational purposes only. It is vital to speak with a financial advisor or legal professional for advice tailored to your specific circumstances. Thank you so much for joining me for this explainer, and hey, here's to officially securing your legacy.